1 p.m. case, Raju Kurchich, secured creditor, 701 Scott Street, Class BD7 beer, wine, and liquor license. Hearing concerning the status of license and the provisions of Article 2B, 10, 4D. Everybody testifying, please step forward and raise your right hand.
I'm sorry, are there any other cases on the 1 o'clock docket other than this one?
Club Okapi.
Okay, yeah, no, I had made Caitlin Harrison from Council President Young's office did mention to me, oh, the letter is into evidence. Okay, great. That they were procuring a letter, and so I wanted to make sure that they knew that this case was going forward. Thank you very much. Let's start the case, and I apologize for that.
Hands, please. Swear or affirm the testimony that you're about to give the truth and nothing but the truth.
Good afternoon.
Good afternoon. For the record, Melvin J. Kanensky representing the licensee, secured creditor at this point. This was a license that the secured creditor, Mr. Kurich, on various different occasions had made a request to transfer to different locations. He ran into about 13 or 14 roadblocks with regard to being within 300 feet of a church or school. His various other pieces of property that are also within the 300 feet. He was just recently had a person want to buy it from 301 Loney's Lane up off of Pulaski Highway. You may find this hard to believe, although there was a bar there for many, many years. It wasn't there for the last 3 or 4. It's lost its zoning. So at this point, he may be relegated to having the license transferred to him at another location, not at 701 South Scott Street. You want to state your name and address for the record, please?
Excuse me, Rajiv Courage, 26 Blackburn Court, Burtonsville, Maryland, 20866.
Now, the information that I've given to the board, is that true and correct?
It is.
And then you have told me that you think that you have another piece of property that may be appropriate to transfer the license to?
I do, within the 46th district.
All right, and then you think that you need about 60 days to do that?
That is correct.
And you're the secure creditor. You've been holding this for that reason?
Yes.
All right, any questions for Mr. Courage? What's your name again, ma'am? I'm sorry. You are Ms. Seibel, okay.
Big Town Community Association.
Will you spell that for us, Ms. Seibel? I have your letter in evidence, but just for the record.
SHERRYSCIBLE.
All right, thank you very much, Ms. Seibel. Would you like to ask Mr. Courage any questions at this time on cross-examination?
Yes. Well, you've had many years since 2007 to transfer this license. What is the problem?
I've been trying to sell it. I've had multiple buyers for it, but it's become very constrained to find a location after the fact because of these various rules out there depending upon schools and churches. And it's been very difficult to find a location which would comply. But I've had about 3 or 4 buyers for this license.
I think that Baltimore City has a large number of bars and taverns, and I really don't see that. How could you have not been able to find a place in this many years?
You can look at the liquor board logs. There's been buyers trying to buy this and going through various locations. All have been denied. It's not through lack of effort.
Can I have other people here, residents, ask questions, or is it just
No,
myself?
we would prefer that any questions that be asked through you. I'll be happy if you'll want to step aside and huddle for a second before asking another question.
Well, I do have another question. When you say you think you have a prospect?
No, I have a prospect, but it's all subject to approval by the liquor board, and that's been turned down 3 or 4 times already, so I can't definitively say until an application is made.
Excuse me. Is there an application pending right now?
No, it's under a contract negotiation right now, but an application will be forthcoming
And when will that be?
as soon as the contract is signed.
You don't even have the signed contract?
No,
or-
we've been negotiating back and forth on the lease term and the purchase
And
price.
how long have you been negotiating?
This party, about 4 weeks.
When do you think you will finish negotiating?
I would anticipate within 2 weeks. And the other option I have is that I will take the license myself, as I don't have a license presently, and I will move it to a location that will comply in the 46th. I'd prefer to sell it. That would be my preference.
When was the last application put in?
Don't recall. I believe about 4 months ago, Fernando Arce. In fact, he tried twice, 2 locations himself, to buy the license.
We have no further
All right,
questions.
thank you very much, Ms. Seibel. Mr. Kudensky, anything to add on your end?
You don't have any intention of move it back to Scott Street?
Oh, absolutely not.
Okay.
Absolutely not. Wait, I haven't, no.
It's fine, I got that.
Excuse me. All right, anything from you, Ms. Seibel?
Yes,
I agree. Ultimately up. There's a letter being presented to us from Council President Bernard Jack Young. All right, while Mr. Kudensky's reading that, are there any argument you want to make, Ms. Seibel?
I have a question first before that. Go forward, please. Mr. Courage, you say that you have 2 options on the books. One, you have a possible buyer.
Yes.
The second option is that you will keep the license and move it to a new location in the 46th.
Unless I can find another buyer for the 46. I have the building, and I will make application.
What is the zoning district for that building?
46.
What's the zoning?
Commercial.
This is a B1, B2,
You know, I
B3?
don't know. I can let you know tomorrow. Lexington liquor zone is.
Can you please speak into the
I'm sorry.
mic,
It's,
please?
the address, I believe, is 2 West Patapsco.
So you're not sure whether or not
No, it's a
building will allow that use to be put in that location?
It's a commercial building. So I don't know the specific zone variance in the commercial, but it is a commercial building. And it's right on Patapsco on the business.
But you do understand some commercial buildings, you can't put a tavern or bar.
Again, I don't know definitively, but I will certainly make application if this buyer doesn't result in a contract.
Well, let me ask you a question a little further to that, 'cause according to the commissioner, you originally had a building on Patapsco that would have been
Yes.
okay zoning-wise, except you were within 300 feet of a
Exactly,
church.
exactly.
This building happens to be further away down the
Exactly.
street, but you own the whole block.
Exactly.
Okay.
All right, board is going to consider some letters, emails in the file at this time. Certainly. I'm sure you had a chance to see them before. They're old. They're from, I guess this case was postponed from September.
Has to do with,
Well, I think it's a bullet. They sent out letters on 3 different places. I believe they were all scheduled for the same day, but due to postponements, they in fact weren't.
I would object to these only from the point of view that he's already stated that he has no intention of moving these back to Scott Street. And all these have to do with the location in Scott Street from which where the license is located. From the point of view that he's already testifying, he has no intention to go ahead and do that. I think it's a moot point.
can I make a point there?
You may argue as to whether or not the emails are to be considered in evidence. That's what we're talking about now.
Yes, well, this is about an agreement that he made with the community association that he would move the business license. He had 180 days and then, one chance to get a hardship extension. And that was in 2007. So he's not standing up to the agreement he made with the community back then as far as his license, what he was going to do with the license. He has all these years and he has not fulfilled that agreement.
I understand that. I don't know that that is the most dispositive part of this hearing, though. I think this hearing is strictly to determine the legal viability of this license. So at this point, we're going to go ahead and receive the letters as a background to understanding why the community is opposing this request, that the community agreed not to oppose said hardship extensions up to a certain point, and apparently, and according to the community, that point has ended pursuant to the agreement with Mr. Courage. So,
That agreement is outside of this hearing.
agreed, agreed. These letters will be admitted as background only, and let's see, a letter from, or email from Jason J. Thomas dated September 26 involving the matter is the protestant's first exhibit. Letter from Heinz Murray dated September 26, 2012, referencing this case among others, is received as the second exhibit on behalf of the protestants. Letter from Carol Ott dated September 25th, 2012, is received as the third exhibit on behalf of the protestants. Email from Kafim St. Hilaire dated October 15th, 2012, and that is received as the protestant's fourth exhibit. There is as well a letter from Ms. Seibel herself, citizens of Pigtown, indicating non-support by citizens of Pigtown. Have you had a chance?
Same objection.
Okay, we'll receive the letter from Ms. Seibel, who's also here today and subject to cross-examination. In a brief moment, that's the fifth exhibit that'll be received and admitted. Sixth exhibit is a letter from Council President Jack Young regarding the license. Ms. Seibel, what would you like to tell us? Certainly.
Brian Dietrich.
Yes, sir. Please
I'm a
spell your.
member of Citizens of Pigtown.
Yes, sir. Please spell your name for the record.
RYAN. Name DIETRICH. The community's position that, DIETRICH.
All right, good afternoon.
Good afternoon. It's the community's position that the fact is that 6 years have passed, or almost 6 years have passed since the agreement, and the way that we understand the law is that unless there's a transfer application pending, because Mr. Courage has gone through his two hardship extensions, that this license should expire by the operation of law. And the reason why the community is here to protest that is not only because it's been going on so long, and we recognize that Mr. Courage has told this board that he has no intention of moving the license or reopening at that bar, but we recognize that sometimes, intentions go away, agreements are forgotten, things of that nature. So from the community's perspective, it's beneficial for us to see the law run its course as we read the law to be, and that is for the license to expire.
All right, thank you, Mr.
Oh,
Dietrich.
can I just ask my question?
You may.
When you said the community, what the community is it?
I'm here on behalf of Citizens of Pigtown.
Which is only an element of Pigtown. Citizens of Pigtown don't represent the whole community.
My understanding is
Oh,
that,
One at a time.
Please. Yeah, Mr. Dietrich is answering questions at this time. Go ahead.
my understanding is that for purposes of this board, Citizens of Pigtown is the designated community organization that can appear in front of this board with the authority of saying that we represent the community, and that the board will give us that recognition.
What I'm asking you is, your understanding is, are you telling me in Pigtown, how many people live in Pigtown? You have any idea?
I don't know.
Is it more than 100?
I would guess so.
1,000? I mean, if you don't know, I'm not.
I
telling
don't
you,
know. I don't.
You know how many members belong to the community of Pigtown? Do you know how many belong to the association?
I don't.
No further questions.
All right, thank you very much.
I have a few questions, Chairman, for the licensee, the secured creditor. Mr. Courage, your first hardship extension request, according to our files, is February 19, 2008. Do you believe that to be correct?
I would assume so.
Would you agree that, based on our records, that you have requested, not before this board, but before the agency, over a 4-year period, 3 hardship extensions?
I can't recall. I mean, for certain, it's certainly been a while. I agree with that.
Our records indicate February 19, 2008, February 10th, February 2010, and then March 10th, 2011. I apologize. October 22nd, 2009 was the second one. March 10th, 2011 was the third one. In February 2010, you filed a transfer application. Is that correct?
Yes.
Have you updated the board? How many applications actually transpired?
Well, I tried myself to move to a building location, but I believe it was like 200 feet from a church.
Okay, how many attempts did you make to move the license?
Myself personally, or
Yes.
through sales?
Just yourself personally?
I think, I don't know for sure, but the last one was at Hanover Street. That's the only thing I recall, but I'm sure I must have tried to move it to another building. It's been a while. I
So
couldn't.
once You tried once.
No, more than once, but once, the last one I recall was at Hanover Street.
So I am looking for specific amounts of time. One time, 2 times, 3 times, you can give me an estimate, but if you're gonna say 1, I'm gonna write down 1.
No, I don't think it's one. I would say at least 3 times I've tried myself, and then I've tried to sell it
How many times have you
subsequently.
tried to sell it?
I've had potentially, I think, 4 contracts on this.
4 contracts, and can you give me a little bit more detail why the contracts didn't?
They could not move it.
They-
They made application with the liquor board, and they could not move it to another location because of the stipulations of, I guess, where you can move to within the 46th.
So you're saying that the district limited the move, not the financial aspect
No,
of the
no, it's not the financial elements at all. The financials were accepted. I, as the secured creditor, could make that determination, and I was happy with that portion of it. It was that they made application with the liquor board, and for one reason or another, it didn't go through.
And some of those reasons include zoning or?
All zoning.
All zoning.
I don't know if you could say the schools and the church requirements being zoning. If it is, yes.
And I may have missed this, but why does it need to be moved?
But I had sold the business to a young lady many years ago, and unfortunately, the clientele that was there was bad. But I was a secured creditor. I got it back, and I did agree that I would move it outside of Pigtown.
You agreed with the citizens of Pigtown?
I'm not sure who the agency was. I mean, at the time, I mean, again, I can certainly look at my old records as well, but I can't recall. But I did agree to move it, and I have no intention of going back anywhere within the environs of Pigtown.
Okay, and just to recap, you currently have a prospective buyer?
I have a prospective buyer, actually 2, okay? One of them that don't have experience in running it. One, they have a Italian bistro in Federal Hill.
Okay, and they have secured a location that is within the law to operate as a BD7?
The one location that I was contemplating, Mr. Kadensky has indicated that would be a very uphill battle. It's the one at 301 Loney's Lane. That is secured, but I don't, he feels that they can make application, but it won't pass. And the other location is a building that I do control, I do own. I suspect it's more than 300 feet, but that needs to be ascertained by the liquor board. And
So it's still a location issue for?
No, I put that out there as a backup in case this buyer falls through and he cannot make good on a location. I have a location, and I will take possession of the title myself of the license.
When do you plan on making this decision?
Within the next 2 to 3 weeks, I'll know if they'll sign a contract. I will put in the contract that they would have to be before the application within 2 weeks of ratification of contract. So it would be time is of the essence. And if for some reason the contract doesn't go through, I'll contact Ms. Schrader and I will make application myself.
I just want to be clear. You are going to wait 2 to 3 weeks to determine if this potential buyer will be able to make application and relocate the license, or you're going to do both. You're going to determine whether they're going to be able to relocate it and put in application, or you will decide to move it to your location.
No, I'm sorry, I wasn't clear. What I'm saying is that I'll give them 2 to 3 weeks to sign the contract with me, and in that contract will be they have to make application with the liquor board, okay? And I can't guarantee that the location will pass, because through past history, I know not to guarantee that.
Okay.
But if that contract falls through, I myself will put a contract in.
Okay, thank you so much. I have a question for your attorney. Mr. Kadensky, can you advise the board your understanding of the law which would either time out an application once a transfer application has been, time out a license once the application has been filed?
Well, there's been an opinion made to the board by both myself, by Mr. David Misters and others, that Section 10504D does not apply to secured creditors because they can never have a business that would ever be open to be closed or cease doing business. So it doesn't apply to receivers, secured parties, parties in bankruptcy, etc. Second of all, with regard to this thing, we have a Baines situation here, Baines versus Liquor Board, where the board over the past 3 or 4 years have accepted the renewal fees. And in the Baines case is exactly on point where it says you can't keep taking renewal fees and then tell the person his license isn't any good. And so for those 2 very reasons, I think there's a very much validity to this question. I'm not really sure why, secured creditors, the board scheduled these 504Ds when we provided, and it's probably in your files, the information concerning why 504 does not apply to secured creditors, as well as, I think everybody agrees, doesn't apply to persons in bankruptcies and receivers. So it's much the same, because the portion of the law was passed pattern Baltimore County's law. David Mister helped pass that law. In his opinion, it's the same thing. It doesn't apply to secured parties. It was never meant to apply to secured parties.
What was the intention or the spirit of the law, if not the black letter of the law? What do you believe that to be?
Well, the intention would be the secured party, as a receiver or a bankrupt, could hold the licensed loans. They're paying it. Every year you get your fees. There's no harm, no foul. You're not creating any hazard or anything to the neighborhood, and that in that case there, it gives them intention to sell an asset to go forward. If you want to know the history of Article 2B 504, it came about because Mr. Peter Angelos in Baltimore County was sitting on 6 licenses at one time. In his case, he was not paying renewal fees. So they passed it, and then when it came into Baltimore City, they passed it. But in that case, he was holding those licenses not as a secured party, but just as a landlord. So the opinion was that in these cases here, since you couldn't do open to close, that the 180-day will never come forward, because you cannot, this board will not allow a secured creditor to operate a business. So they can't open to close. They're holding it as an asset, much like a bank would hold it. You wouldn't use that same argument against Bank of America, who's a secured party. They come in here all the time. Susquehanna Bank comes in here and makes the same arguments to you. So I think from the point of view that there is that argument, and that the Baines, that you've been taking the renewal fees, which is exactly on point. Maybe it's something, I don't know whether anybody's renewed it, but in my case, I took the Court of Special Appeals, so I know pretty much what it is. That is something that should be looked into in this case. Plus, Mr. Keurig here said that he has no intention of moving the license back to Scott Street. So from that point of view, the citizens of Pigtown or the Pigtown people shouldn't have any type of trepidation about him being there. The only thing is that he has an asset that, unfortunately, the person was in there went under, and he's got to try to recoup his asset.
Nothing further, Chairman.
Any questions? Commissioner Jones?
None.
All right. Any further comment? Mr. Dietrich? Any closing arguments?
And by our position of law, that it applies to specifically the licenses. The license holder, I guess, would be secondary to that if I read the statute.
Thank you. Last word?
Yeah, obviously, the license holder is the most important. You're not about to tell some bankruptcy trustee that the citizens of Pigtown trump whatever is going to go here, and I don't think you would do that, nor any receiver in the case. I think the law is clear as to how it applies. Taking that into consideration with the Baines case, I think there's validity subject to not being transferred in that location.
All right, thank you very much. Let's go off the record. Deals with transfers is to break out a file, and we, based on a case that's been going on since 2008, the board feels it's more than prudent for us to review the application, the transfer application file from December 13th, 2011, and the transfer application file from May 8th, 2012 as well. So we'll ask that someone pick those up from the agency across the street and bring them over to us to review so that we can establish a timeline with our own documentation portal. Go off the record in this case and proceed with the next case. We will attempt, we cannot promise, but we will attempt to have a decision in this matter before 3 p.m. Thank you. We're off the record.
Thank you.
It's better than making you come back again.
Yeah.
This way we can get it.
I understand that issue. It's a civil matter. I mean, Mr. Koninsky can be here in your stead if he's got somewhere else to be. But I think he's going to be here all day. Yeah. Okay. So no, we'll hold him harmless, and we understand that. All right. Thank you.
Good afternoon, ladies and gentlemen. The court proceedings are about to begin. If you please cut up your cell phones and all electronic devices, and please refrain from cyber conversations due to sensitivity recording devices. Thank you.
All right. Good afternoon. We're going to go to our decision phase.
Bryson is in here, Chairman.
Oh.
The track the court.
We take
I'll
this
find.
prices in here.
Right.
Okay, I'm willing to go there. Mm-hmm.
What did she say?
As hardship extension was granted. 12, transfer. After that, told period from 410 to 72. Jane says
No.
it was 72, which
No,
would
no.
which would cost him another. No, would actually add another 3 days to the license.
This is all
I'm just looking at the file of what says is Jane Schroeder.
based on the,
Okay,
Look on the back,
I'm sorry about that.
right, that's incorrect.
on the back sheet.
Oh, okay. Okay, fair enough. And it was received that day. Yeah, okay. All right. Let's go on the record in our decision phase, November 29th, 2012. Rajiv Courage, secured creditor, 701 Scott Street. This is a hearing concerning the status of the license at the 701 Scott Street location. Board heard argument, received several exhibits, including a summation of some of the key dates in the transfer history of this location from 2008 to the present. We reviewed Protestants 5, which was the summary compiled by Ms. Seibel, the treasurer of Citizens of Pigtown. We verified that information with the help of several files. The board, in looking at Article 2B 10504 and 504D, we note that we last granted a 180-day hardship extension on March 26, 2012. After that time, the licensee filed a transfer application on May 10th, 2012. That application was withdrawn by fax via Mr. Courage's counsel at the time, Lisa Harris Jones, on or about June 29th, 2012. From June 29th until today's date, November 29th, no hardship extension has obviously been filed because there are no further hardship extension requests to be made. That's 150 days from June 29th until today. There was the period of 24 days from 14 days from March 26th, 2012 through April 10th, 2012. So based on our understanding of what we have already done in the prior hardship extension requests granted, that means that this license has 164 days of its 180 days on the hardship extension having expired, meaning that this license is, in fact, we're declaring this license viable for another 16 days. And what that means is that if an application for transfer is not filed within 16 days, this license is in fact, and we're determining that this license will expire by operation of law 16 days from today. If an application for transfer is filed and withdrawn, the license expires by operation of law. If the transfer is not approved, and if it's denied by the board, this license expires by law. Obviously, I would entreat your client to try to find a buyer forthwith, and that's the board's decision based on the evidence that we've received, and more importantly, based on a review of the files for the 2 or 3 previous transfer attempts with the license and the hardship extension request hearing transcripts that we have gone through. That's the evidence that we've reviewed to determine where we are with this license, and we are determining 3-0 as a board that, in fact, this license is viable and shall expire 16 days from today's date. Thank you very much. We're off the record.
Thank you.